It started as a normal morning in court, but within minutes, the judge's patience would be tested, and one man's truth would change everything.
My colleague, the University of Maryland onesie, for her to put her new baby in a few months. So,
Which one?
the terrapins, the red.
No, I know what the
which
onesie
college?
is. Which college?
Lauren. I chose Lauren because I think she's in front of me more than Hannah, but
Yes.
now I'm regretting. I don't know if that was the right choice. Although I guess I could give it to both of them and have both of them share it. I don't think that.
I don't know about sharing baby clothes. I will just say this. Give it to Laura.
That was my.
Because if she's in front of me, I can make her bring the baby in with the Maryland onesie.
The terrapin onesie.
Yeah, there we go. Except I'm mad at the terrapin right now.
Oh,
I just
not caught up. Rough weekend.
Just, you know, I love them and I'm watching them. They're good. They're a good team, but they're young. So they just don't go the whole 60 and they make a lot of mistakes. And I just like, if you can cut all that.
They play this weekend?
I don't even know who they play.
Michigan plays Washington.
What'd you say?
Michigan plays Washington.
Michigan plays Washington. Maryland. I don't know who Maryland's playing.
I don't know. All I know is I do live close enough to sell parking to home games, and I've never done it because it takes a lot of time and effort to like stand out there with your sign, but it's also money. So
Maryland plays UCLA this weekend.
oh,
Which is going to be a problem.
but is UCLA that good this year?
They beat Penn
They-
State.
I don't know how good they are, but they've definitely been handling business.
Yep, they've been doing things. And we should have beat Washington. We should have beaten Nebraska. And now we're going to play a hot UCLA team.
And that was the game that led the coach to being fired, right? Now the coach is fired from Penn State,
Yes.
right? And he got what, $56 million?
49, yeah.
$49 million.
Yeah. So after 40, does it really matter? I don't know.
That extra stuff.
Luckily, they have a really smart clause in his contract for his buyout that if he has to, he's required to look for a new job.
Oh.
And if he finds a job that pays, I think it's more than $8 million,
Oh, I didn't hear this.
they only have to pay the remainder, and that school will take up the rest of it.
Oh.
Yeah, smart contract clause.
Wow. I was going to say, he's just set.
Yeah. We just need a dude with a gun to like tell the prosecutor what to do. He's gonna waive.
Oh, he's going to waive? Oh, even better. Okay. Yeah. Are you ready to go ahead on that then? Or
Sorry?
are you ready to go ahead on that waiver?
Yes, Mr. Matt Stewart could come out and waive.
Okay. Bring it back.
I'll just write it off while we're talking.
I'm done. Court does call the case of the people of the state of Michigan versus Max Stewart.
Assistant Public Defender Ben Denowith on behalf of Mr. Max Stewart, who is joining me at the podium now. Sir, would you state your name for the record, please?
Hezekiah Max Stewart.
And Your Honor, I do believe we have a deal for a waiver of exam in this case.
Okay.
In exchange for waiving his exam, the prosecution is offering to let my client plead guilty to counts 2, 3, and 4 at a future date in the circuit court. And at that time, or at the time of sentencing, count 1, the 10-year felony would be dismissed. Is that correct?
That's correct, Judge. He pleads to counts 2, 3, and 4 in the circuit court with dismissed count.
All right, so, but he's waiving his preliminary examination.
Yes.
Sir, is that correct?
Yes, sir.
And you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
For the record, people also waive their right.
Yes.
Preliminary examination having been waived, defendant is bound over to circuit court on all 4 counts.
Your Honor, he's just signing the form now.
All right. But while he's doing that, you waive formal reading. Your client stands mute.
Yes, Your Honor.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea.
In this Michigan courtroom, a defendant stood trembling, charged with operating while intoxicated. He claimed it was a mistake. 4 tiny bottles of vodka that ended up costing him everything. As the judge read the plea deal, the courtroom fell silent. Every word mattered. Every answer could seal his fate. What looked like a routine case soon revealed a man torn between guilt, fear, and desperation to be forgiven.
As to all 4 counts, pretrial in this matter will be set for
October 27th at 1:30 for judgment.
October 27th, 2025, 1:30 before Judge Hamoud. Bond will continue.
Thank you, Your Honor.
Thank you. What was Warren Green doing on his?
I think we're holding on that one.
You're going to hold on Warren Green.
Yes.
Okay.
We'll grab a court. HDMI cord.
Pardon?
Can I run down to our office and grab a HDMI cord?
Sure. An HDMI cord? Is that what you need?
Yes.
We've got.
There's one here, but I don't want to take it.
What, are you going to play something?
Yes.
Video? You can, cord can be moved, but you can also play it from the podium if you need to.
Okay.
So either way, if you want to go grab one, go ahead. Take a stroll. We'll be here. No, that's okay because I've got a case I can handle and then.
Okay.
All right. Or one that might handle me. Mr. Warren Green, we're holding on yours.
Yes, we are, Your Honor.
All right.
I think we should approach.
I heard that. I said, no, they're not. I'm not talking to them. I'm not no. With you two, it could get real bad. It could just get bad. I'm just coasting along during the day. And the things people were saying about you, you disappeared. No, I was defending you. I was, what? Oh, it was horrible. It was horrible, some of the things they were saying. Wasn't it bad? It was, it really was. Is this like an approach or we need to sit down and have the conversation?
I'm trying to avoid your chambers. I feel bad taking people's time up if it's,
What?
I feel bad taking time up if we can, but I'd be happy to oblige with whatever.
She's so demanding. She just has her way. I'll see them in chambers because they're going to yell at each other. They were both, I'm watching the two of you and you're over there with each other animated. And then can we approach? Going back and talk. I'll talk on that when everybody can remain seated. And when Warren Green and, well, I don't have anyone, never mind. I'll deal with that. Well, not yet so easy. Court does call the case of the people versus Jeffrey Sanders.
Good afternoon, Your Honor. Retained Assistant Prosecuting Attorney on behalf of the people.
And Laura Yagi, Assistant Public Defender on behalf of Mr. Sanders.
All right. And he's.
So, Your Honor,
go ahead.
Was the date and time set for preliminary examination? Before we even got to that point, there was some conversation I had with defense counsel regarding proceeding with this case, and also information I received that there is a CPS investigation That investigation is based on the reports that defendant has been living with, or at the very least staying with the victim in violation of his PPO as well as violation of his bond conditions. I informed counsel of that. I know we had a chambers conference regarding that matter. It was the people's position that we were going to ask for remand to keep him in custody until we could have a bond violation hearing and to adjourn the exam to follow. The victim was not present here this morning, although there was some back and forth about whether or not she was on her way. The victim had expressed great fears about showing up here today and what the defendant would do if he knew that she was going to testify. After our chambers conference, Your Honor, I came out to call the victim. There was some conversation about having the victim appear via Zoom. So Deputy Raymond Hall and I called the victim to have a conversation with her about the possibility of her doing that. During that conversation, towards the end of the conversation, she caught our attention as we were hanging up the phone and said the defendant had been texting her throughout this whole day, essentially, throughout this whole procedure, and that she wanted someone to go look for him because he had texted her that he was going to run. I then left the conference room right away. I informed Public Defender Yagi about what we had learned and was looking for the defendant. My understanding at that point from Ms. Yagi was that the defendant was going to go use the restroom. I came out in the hallway. That is what he claimed he was doing. I had Deputy Raymond Hall follow him based on what we had just learned. Next thing I know, I was back in the courtroom. I heard police stop. And when I went out in the hallway, the defendant was no longer there. And it was my understanding that he had taken off.
In my understanding with reports from security that he took off, it would be the southern emergency entrance out of this building headed in a southerly direction. Ms. Yagi, anything?
Your Honor, I don't think there is anything I need to add at this point.
Based upon that, and this is date and time set for preliminary examination, I'm going to issue a bench warrant for the defendant's failure to appear. There will be no bond. That warrant will issue immediately. I have also marked the file that this matter, initially anyway, it might ultimately be set before Judge Washington, but should be set before me when we get him, and we will.
Thank you.
All right. Thank you. And that was going to be a bad conference. Ready? No. Not letting that go. Court does. Can we get Mr. Burke out, please?
Yeah, can you please have Mr. Burke in courtroom too? Thank you.
Oh, you got the other paperwork because you're waiting for his signature.
That's correct.
Okay. Let's call the case of the people versus Jamie Burke.
Alex Chavalowski for the people.
And Alex Warren Green on behalf of Mr. Burke. Mr. Burke, when you get up here, can you please state your name for the court?
Good afternoon, Your Honor. My name is Jamie Cayley Burke.
All right.
This is the plea agreement. Can you sign here?
Your Honor, this plea agreement.
And this is the terms of
Okay. While he's signing that, my understanding of the plea agreement is that the defendant is going to be pleading no contest to the charge of second degree. On his plea to that charge, count one would be dismissed. There is also, once I get the form, some agreements that
That's agreement for 2 years probation and restitution agreed on at $1,242.
This is the advice of rights. And Your Honor, Mr. Burke is now signing the advice of rights form after I just provided the court the...
I can't actually be at that address for a year.
Okay. Right, your address?
Okay.
That's fine.
Homes.
Yeah. Just...
That contact number as well.
Okay.
plea is right here. I have it here. Thank you so much. Yes.
Yes. Mr. Warren Green, that was a correct statement of the agreement.
It was, Your Honor. It's a full understanding.
Okay, sir. May I have him sworn?
Right. You solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and the truth so help you God.
Yes.
State your name, please.
Jamie Kaylee Burke.
All right, sir, it is this court's understanding that you are going to be pleading no contest to the charge of retail fraud in the second degree. That's a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that becomes the maximum fine. You understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right, 2 things about it I have to make sure that you understand. The first thing is that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and I will check the sentencing judge waiver of the form. But you will be sentenced before Judge Valvo in the 15th District Court. You understand that?
Yes, Your Honor.
All right. Basis for the no contest plea.
Potential civil liability, Your Honor.
All right. Sir, to the charge of retail fraud second degree, how do you plead?
No contest.
Now, you understand that by pleading no contest, that you'll not have a trial of any kind.
Correct, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights of that form.
Correct, Your Honor.
You understand you're giving up your right to appeal of right?
Correct, Your Honor.
Are you on probation or parole?
Jamie, at the time of the offense, you were, right?
Correct.
And you've been violated by Lenawee County for the arrest in this, right?
Correct.
Okay, so you were on probation. You're indicating they have taken sanctions for this?
They have, Your Honor.
All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily?
Yes, Your Honor.
Of your own free will?
Yes, Your Honor.
Okay, the court has been handed Ann Arbor Police Department report for their case number 23-57552. Any objection to the court having reviewed that report?
No. None from the defense.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you from the time of me accepting your plea and the time of your sentence, if you commit misconduct as defined by the Michigan court rules, that you would not be entitled to any sentence evaluation or recommendation to the court. The court would no longer be bound by that. You understand that?
I do, Your Honor.
And you understand also you would not be permitted to withdraw your plea.
Correct, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements that have caused this plea?
None that have not been stated on the record.
None from the defense, Your Honor.
All right, and has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes.
Defense is satisfied.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
November 4th at 9 a.m.
set 4th.
Yes.
December 4th, 2025, 9 a.m. before Judge Valvo.
I'll do it.
Bond in this case will continue.
Thank you, Your Honor.
Thank you, sir.
Thank you, Your Honor. Welcome.
Okay. That's all that I have, right?
Yes.
So there are people staring at me?
Yes.
Are we, oh, they were with that case. Gotcha. Okay. I don't, yeah, might want to find out. Not right this second.
Are these yours?
Veronica Webster.
Veronica Webster?
Webster. Webster.
I didn't have that. You have that one.
No, but
In
What kind of case?
Oh, was it on my original document
Yeah.
this morning?
Yep.
I'm double.
Okay, because of an emergency, I had to cancel my civil docket.
Oh.
And let me just double check. And so I handled the criminal docket that I just finished up, but
She was.
Thanks. Thank you. Appreciate it.
all right. So the cases from today, they're here on a civil matter
They went to the 28th
at 9.
at 9 a.m. Yeah.
Okay, so we had to move those 2 weeks out. Sorry, folks.
You all day, how you been?
You've been here all day with me? How'd I do?
You did a great job.
Well, thank you. All right, you take care. We'll see you in a couple weeks. Yes, ma'am.
Ma'am, if you see the clerk's office, they can give you a notice to take with you.
Okay. Do you think we should go for it?
I think he should be in custody.
No, I want to go on the record, yeah.
I know.
They found him, Your Honor, so I don't know.
Pardon?
if the court wanted to, I'm sorry, on Mr. Sanders, they found him, but they have him.
They have him?
They have him. Excellent police work. I don't know if the court.
Best in the state.
Do anything today?
Oh, yes. If you guys have time, let's bring him to me.
Your Honor, if I may, I'll go and pick him up right now. He's just around the corner.
Fantastic. I'll be here with bells on. All right, court is standing brief recess. I need that file back.
Yeah.
Get out of here like this. I will pull you in.
Well.
Oh.